2311 Racing finds itself in what can only be described as the trickiest corner in all motorsports. The team's legal battles against NASCAR reached a precarious point this June when a three-judge panel from the Fourth Circuit Court of Appeals vacated the preliminary injunction that had been granted to them back in December 2024. This decision gave NASCAR the right to sell the team's charters at will. But here's where things get interesting. To restrict NASCAR from doing exactly that, 2311 Racing and Front Row Motorsports filed for another injunction and a restraining order. The results of this filing were expected this week following assessment by a judge. Based on the outcome, the teams could retain or stand to lose their charters entirely. Most fans don't realize just how much power these charters hold. Chartered teams receive a guaranteed spot on the grid each week. Open teams must qualify on speed alone. But that's just the beginning. Chartered teams receive a portion of revenue from NASCAR's multi-billion-dollar media rights deal. Open teams don't get a single penny from that massive pot. Regardless of finish position, open teams earn far less money than their chartered counterparts. The financial gap is staggering. Loss of charter status would compromise and void contracts with sponsors and drivers. We're talking about millions of dollars hanging in the balance for a team like 2311 Racing, which fields the number, 23 Toyota Camry for Bubba Wallace number, 35 Camry for Riley Herbst and number, 45 Camry for Tyler Reddick. Losing charter status would be catastrophic. 2311 co-owner Denny Hamlin didn't mince words when he revealed what Discovery had uncovered. Speaking on his Actions Detrimental podcast, Hamlin said the latest filing was warranted after Discovery revealed a monopolistic series of acts that have occurred. Hamlin explained,
"We obviously filed a new preliminary injunction, and we also filed a restraining order against NASCAR, and the basis for the two are through Discovery, we have obviously revealed, and again, so much of this is redacted. Discovery has revealed like a series of monopolistic acts that have occurred, and so we believe that
the fact that much of this evidence remains redacted suggests the information is either highly sensitive or potentially damaging to NASCAR's reputation. Hamlin believes the status quo of having their charters should not be disturbed until the case resolves on December 1st in the courtroom. Hamlin stated,
the reason being, right, is that, and to kind of explain the restraining order, we're seeking for them not to be able to take and then sell our charters because, if we prevail in December, how do you go get that back? You can't.
Hamlin's confidence stems from what he describes as strong evidence of NASCAR's monopolistic acts in the stock car racing platform. The team doesn't think it's right for NASCAR to have the power to sell their charters while legal proceedings continue. Jeffrey Kessler, attorney for 2311 and Front Row Motorsports, released a statement explaining their position. Today we filed a motion in the district court for a renewed preliminary injunction and temporary restraining order to protect the team's ability to race chartered for the remainder of the 2025 Cup Series season and prevent irreparable business harm to 2311 and Front Row Motorsports until we can present our case at trial in December. Kessler added that new information surfaced through the discovery process that overwhelmingly supports our position that a preliminary injunction is legally warranted and necessary. Despite the mounting legal pressure, Denny Hamlin made one thing crystal clear. The team will continue racing regardless of charter status. Neither Tyler Reddick nor Bubba Wallace has won a race yet in the 2025 Cup Series season, but both drivers currently sit in contention for the playoffs based on points. Hamlin said this on Actions Detrimental.
2311 Racing going forward, whether you're an open team or not an open team.
We're going to race. One thing is for sure is that we've always said that we're committed to racing this season, whether it be chartered or unchartered. But certainly there's been some evidence that has been revealed that warrants this preliminary injunction.
If the charters get revoked, the drivers will have to race as open entries. There's a real chance they could miss a race or two by doing so. Hamlin admitted such a situation would be detrimental since they would miss out on gaining crucial playoff points. However, the hope remains that things don't come to that.
NASCAR gets what they want and you guys have raced as open teams, how does that impact Tyler and Bubba racing for playoffs and going forward? Does that, they can still...
Yeah, everything would be the same there as far as trying to race for the playoffs. Obviously, if you miss a race, it makes it harder because you miss out on those points. And so hopefully it doesn't come to that.
The legal saga began on October 2nd, 2024, when 2311 Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR. The lawsuit challenged the terms of the updated charter agreement and anti-competitive practices committed by the France family. On December 18, 2024, both teams received a preliminary injunction, allowing them to race as chartered entries in 2025 while continuing their legal battle with NASCAR. The injunction also allowed the transfer of 2 Stewart-Haas racing charters to both teams. Everything changed on June 5, 2025, when the U.S. Court of Appeals overturned the preliminary injunction ruling. 2311 and Front Row Motorsports found themselves set to lose their chartered status on Wednesday following the appeals court decision. The teams wanted NASCAR to file a response by Tuesday afternoon. The judge gave NASCAR until 5 p.m. Eastern Time Wednesday to respond to the latest filing. The implications extend far beyond just 2311 Racing and Front Row Motorsports. This case could fundamentally alter how NASCAR operates as a business. The team's legal challenge centers on what they describe as NASCAR's monopolistic control over the sport. 2311 Racing operates as an American professional auto racing organization that competes in the NASCAR Cup Series. The team is owned and operated by Hall of Fame basketball player Michael Jordan, along with current Joe Gibbs racing driver and 3-time Daytona 500 winner Denny Hamlin. The team name represents a combination of the number 23 Michael Jordan wore during most of his NBA career and the number 11 which Denny Hamlin has driven his entire Cup Series career. The organization also fields the number 67 Camry part-time for Corey Heim. They maintain a technical alliance with Joe Gibbs Racing, which provides additional operational support. The legal challenge extends beyond just these 2 teams. Kessler emphasized that the team's love of stock car racing and belief in a better future for the sport for all parties, teams, drivers, employees, sponsors, and fans, continues to motivate their efforts to pursue this antitrust case. This case could establish precedent for how NASCAR conducts business with teams going forward. The discovery process has apparently revealed information that the plaintiffs believe demonstrates anti-competitive behavior by NASCAR and the France family. The 3-judge panel that vacated the initial ruling in June did so because the teams had not demonstrated a likelihood of success on their antitrust claims. The question now becomes whether new evidence uncovered through discovery changes that assessment. Everything culminates on December 1st when the case goes to trial. Until then, 2311 Racing and Front Row Motorsports fight to maintain their charter status and continue operating as full participants in NASCAR's Premier Series. The immediate focus remains on this week's restraining order decision. If successful, the teams maintain their charters through the remainder of the 2025 season. If unsuccessful, they face the prospect of racing as open entries with all the financial and competitive disadvantages that entails. Hamlin's confidence in their legal position stems from what he describes as overwhelming evidence of monopolistic behavior
against NASCAR, and the basis for the 2 are through discovery. We've obviously revealed, and again, so much of this is redacted. Discovery has revealed like a series of monopolistic acts that have occurred, and so we believe that status quo of us having our charters should not be disturbed until this is resolved on December 1st in the courtroom.
The redacted nature of much evidence suggests highly sensitive information that could prove damaging to NASCAR if made public. The teams clearly believe they possess smoking gun evidence that will vindicate their position. For NASCAR, the stakes are equally high. A loss in court could force fundamental changes to how the sanctioning body operates and distributes revenue. The charter system itself might face restructuring if the court finds merit in the monopoly allegations.